Muslim laws of marriage and divorce. If a Muslim husband has falsely charged his wife with adultery, the process of retract is called lien. Zihar is a method of divorce of Muslim law in which husband compares his wife with his mother, under which law an old woman had no more chance to become pregnant, need not to perform iddat. Sefai. Under the Muslim law, Khula and Mubarat are the form of dissolution of marriage by agreement. Which one of the following is not a source of Muslim law? Shariat. Hadith is one of the source of Muslim law. It comprises word and action of the Prophet. On the ground of fosterage, Muslim marriage is void, batil. Which one of the following are sources of Muslim law? All of the above: Quran, Ijma, Qiyas. The legal guardian of Muslim minor female is father. A dowry may be regarded as consideration of covenantal intercourse by way of analogy to the contract of sale. The above observation made in which one of the following cases? Answer: Abdul Qadir versus Salima. Manya Baby versus Chaudhry Wakil Ahmad, 1925. PC. Privy Council is related with which topic under Muslim law? Answer: dowry. Under the Muslim law, in the gift, there are following parties, namely donor and donee. Muslim marriage is a religious sacrament too. It was laid down in the case of Anis Begum versus Mustafa, 1933. A marriage of Sunni male with Muslim female of any sect is valid. Dower in Muslim law is An obligation imposed upon the husband as a mark in respect of wife, consideration for marriage, a legal right of the wife. These three are right. C is right. How many grounds of divorce are provided for Muslim women under Section 2 of Dissolution of Muslim Marriage Act? 9. Iddat period. In case of divorced women, if she is subject to menstrual, means three menstrual course after date of divorce. Talaq ul biddat is complete and irrevocable divorce. A Muslim goes into any country of the world with an object to obey the law of the country concerned, which include personal law. Marriage in Muslim law is a civil contract. Marriage during iddat period is fasid. What is the age of puberty for Muslim marriage? 15 years. After the death of husband, a Muslim woman can retain possession over her husband's property until the dower is paid. This is her right of retention. According to Section 4 of Dissolution of Muslim Marriage Act 1939, apostasy from Islam of a Muslim wife will not dissolve her marriage ipso facto. According to Sunni law, chief source of Muslim laws are Quran, Hadith, Ijma, and Qiyas. The Muslim Women Protection of Right on Divorce Act was enacted in 1986. If a Muslim minor has been contracted in marriage in his minority by a guardian, such a person has a right on attaining majority to repudiate the marriage. This is known in Muslim law as Khiyar ul Bulug. Samim Ara claimed her dower after the death of her husband from her husband's property. She is an ordinary unsecured creditor having no priority over other unsecured creditor, subject to her right to retention. In which one of the following is the most approved form of divorce under law? Talaq-e-tafweez. A contract of marriage between A and B is made in joke and without any specific intention. Such marriage is valid under Hanfi law. If A make a hibba of retaining property to B with a condition that B shall not transfer the property, then condition is void and hibba is valid. Under Sunni law, a marriage performed during the period of iddat is irregular. After declaration of waqf, the property became vested in God. A Muslim woman deserted by her husband without divorce is entitled to maintenance under Section 125 of CRPC. Has been declared by the Supreme Court in the case of Muhammad Amjad Khan versus Shah Bano, 1985. Ijma as a source of Muslim law means an anonymous opinion of Muslim jurist. In which one of the following cases Supreme Court has held that marriage of all persons who are citizens of India belonging to various religions should be made compulsory registrable in their respective state? Seema versus Ashwini Kumar. Saira Bano versus 2017 case is related to triple talaq. Which one of the following is not a ground of divorce under Special Marriage Act? Conversion is not a ground. Adultery, cruelty and desertion are ground. Under Muslim law, following are guardians of marriage of a minor. First one is father, after him brother, then mother, then state. Option C is right. Consider the following preposition. A Muslim woman on her husband's death need not to follow iddat if her marriage is valid but not consummated. Wrong. A Muslim woman on divorce need not to follow iddat if her marriage is valid but not consummated. True. A Muslim woman on divorce to has to observe iddat if her husband is irregular, if her marriage is irregular but consummated. True. A Muslim woman whose marriage is void but consummated has observed iddat till delivery if she carrying a child in her womb in case of her husband's death. Wrong. Mutta marriage come to an end by Hibai Muddat. A Muslim woman need not to observe iddat in which one of the following? All of the above. Mutta marriage, irregular marriage, valid marriage. Khilawat al-Sahi connotes valid retirement. A dower debt is an actionable claim. Which one of the following is the legal consequences of divorce under Muslim law? All of the above. The party acquired the right to contract another marriage, cohabitation between unlawful, mutual right of inheritance. In Muslim law, hizanat related to mother's custody of child. Under Dissolution of Muslim Marriage Act 1939, a Muslim wife can get a decree of divorce if the husband has been insane for the term of 4 years. Dissolution of Muslim marriage due to apostasy from Islam by husband is effective immediately. When a Muslim mother loses her right of hijanat, custody, all of the above, by her apostasy, by her misconduct, by marrying within the degree of prohibited relationship. Hijanat means both A and B. Custody of mother upon child only, custody of father upon child only. Among Muslim, which school does not mention minimum amount of dower? Shafi'i. Implied and contingent talaq is not approved by Shia. A Muslim woman can seek divorce if the husband is not traceable for a period of four years. Under the Muslim Women Protection of Rights on Divorce Act, the option to govern the provision of Section 125 CRPC may be given by parties either jointly or separately. Match: Ruqayya Khatun versus Abdul Raskar. Reconciliation should precede talaq. Saida Bano versus Union of India. Triple talaq is unconstitutional. Sameem Ada versus Union of India. Uncommunicated talaq is not talaq. Daniel Latifi versus Union of India. Divorced wife is entitled to meher, reasonable and fair provision for future. A divorced woman can apply directly to Waqf board when there is no relative to support her. This was held in which one of the following case? Secretary, Tamil Nadu Waqf Board versus Saeed Fatima Nachi. M, the mother of Muslim minor daughter, contracted her in marriage in the lifetime of her father, who had become an apostate. The marriage is valid. A marriage of Muhammadan, who is of sound mind and has attained the puberty, is brought about without his consent. The marriage will be irregular. Halala is related to Muslim women. A marriage with the women before completion of her iddat is irregular. Marriage during iddat under Sunni law is irregular. Hibba is immediate unqualified transfer of the corpus of the property without any return. Evaj. This definition was given by Tyabji. Which one of the following is a secondary source of Muslim law? Custom. Which one of the following modify the application of Muslim law? All of the above. Muslim Marriage Dissolution Act 1939, Muslim Women Protection of Right on Divorce Act 1986, Shariat Act 1937. Who applied Qiyas for the first time as a source of Muslim law? Imam Abu Hanifa. Which one of the following is absolute incapacity for the marriage? D. All of the above. Consanguinity, affinity, fosterage. A Muslim can marry any number of wives, not exceeding 4. 4. If a Muslim marry fifth wife, the marriage shall be irregular. After divorce, a Muslim woman can marry only after completion of iddat. How many witnesses are necessary in Shia Muslim marriage? No witness is required in Shia. In Sunni, two witnesses is required. Which one of the following is the wife's right when her husband does not pay dower? All of the above. Refuse consummation, file suit for recovery of dower, keep possession of a dead husband's property. Custody of illegitimate child belong to the mother. Essential requirement of a Muslim marriage are both Qabul and Izab. During the term of Muslim marriage, neither the husband nor the wife has right to divorce. In which one of the following case the court held that divorce is good in law though bad in theology? Sarabai case. A Muslim make a gift in favor of non-Muslim. The gift under Muslim law is valid as religion is immaterial in gift. A bequest made to a person who causes the death of the tester intentionally under Sunni law is void. In a Muslim marriage where the age of the bride is below the age of puberty, but the consent for marriage was given by the guardian, the marriage is voidable. A marriage between person with consanguinity relationship under Muslim law is batil. Under Muslim law, the marriage, whether consummated or not, iddat has been observed in the case of both divorce by husband and death of the husband. In Muslim law, divorce of lien is right available to the wife only. Under Muslim law, a prompt dower is payable when demanded by wife. In a Mubarak divorce under Muslim law, adversion is mutual and on both sides. In Shia Muslim marriage, how many witnesses is compulsory required? No witness. In which one of the following case it was held that only in case of triple talaq halala is mandatory before remarrying to same husband? Muhammad Ghafoor versus Sabina. When Muslim wife can relinquish her meher? When she has attained the age of puberty. Under Muslim law, a man is forbidden to have two wives at the same time if they are related with each other by all of these: consanguinity, affinity, fosterage. What is iddat period prescribed for widow under Muslim law? A and E. A. 4 lunar month and 10 days in the case of divorce, and E. Widow. Widow must be none of these, not A. Wrong answer. For widow, it is 4 lunar month and 10 days. Under Muslim law, a divorce by khula, this one is A is right. Under Muslim law, a divorce by khula is a divorce with the consent at the instant of wife. When is iddat observed for 3 months on divorce? Talaq, which cannot be revoked after pronouncement, is called talaq ul ban. Under the Dissolution of Muslim Marriage Act, a woman can seek divorce from her husband if he continues to be impotent after marriage. If he impotent at the time of marriage. Both A and B are right. Whether a Muslim may give talaq in the state of intoxication or under pleasure. Yes, recognized under Sunni Muslim law. Which one of the following reason lead to setting aside the practice of talaq-e-biddat, triple talaq, in Saira Bano versus Union of India 2017? Section 2 of the Muslim Personal Law Shariat Application Act 1937 was a pre-constitutional legislation within the meaning of Article 13(1) and violation of Article 14 Constitution of India on the ground of arbitrariness. This one is right. This one is wrong. This one is right. A Muslim Personal Law Shariat Application Act 1937 is not a regulating triple talaq, but practice of triple talaq was against the basic tenet of Holy Quran, and no practice against the tenet of Quran was permissible. Right. This one is also wrong. So the option is 1 and 3. D is right. A wife under Muslim law is entitled to obtain decree of dissolution of marriage on the ground of all of the above: failure on the part of husband to perform marital obligation for a period of 3 years, cruelty by husband, insanity by husband. By the third pronouncement, utterance of talaq, which kind of talaq became effective? Talaq-e-Hasan. In which one of the following case the Supreme Court has held that the 3 talaq would be treated as a single talaq, not a valid talaq? Samim Ara versus State of UP 2002. The most popular divorce is Ashan Talaq. Divorce by mutual consent in Muslim law is Khula or Mubarat. Which of the following enactment provide the ground for divorce available to wife only? Dissolution of Muslim Marriage Act 1939. Talaq Talaq-e-Ashan is revocable during the period of iddat. If husband swear that he will not have sexual intercourse with his wife for 4 months or more, it amounts to a form of divorce known as ila. Right of Muslim Protection of Right on Divorce Act 1986 deal with maintenance right of divorced Muslim women. A Muslim wife may sue for divorce under the provision of Dissolution of Muslim Marriage Act if the husband has been insane for a period of one year. In which one of the following is not a ground of divorce provided by Dissolution of Muslim Marriage Act 1939? Conversion of husband to some other faith. Which one of the following is not a form of divorce in Muslim law? Fasid. Iddat period of a divorced Muslim woman who was pregnant at a time of her divorce is period between the divorce and the delivery of her child or the termination of her pregnancy, which is earlier. Which one of the following ground is not available to Hindu and Muslim wife both to claim divorce? Husband renounce the word by entering into any religious order. This one need to be considered. Which one of the following is not available to a Muslim wife to seek dissolution of husband? Husband has changed her religion. Okay. Matrimonial remedy of judicial separation is not available under which one of the following enactment? Dissolution of Muslim Marriage Act 1939. Impotency of a spouse on ground of divorce under which one of the following matrimonial legislation? Dissolution of Muslim Marriage Act 1939. A man and a woman, both Muslim, get married under classic Muslim law and then get their marriage registered under Special Marriage Act 1954. A year later, the husband pronounces a talaq on his wife and get married second time. The second marriage is void as right of talaq is not available to the husband. A minimum of 2 years separation is necessary for obtaining divorce by mutual consent under the provision of Divorce Act 1869. The rule of unlawful conjugation under Muslim law related to marriage of a man with his wife's sister. The matrimonial relief of annulment of marriage is not available under the Dissolution of Muslim Marriage Act 1939. Mubarat under the classic Muslim law referred to divorce by mutual consent. Whereabouts of husband is not known for a period of 4 years is a ground of divorce under Dissolution of Muslim Marriage Act 1939. Iddat under Muhammadan law referred to none of the above. A divorced Muslim woman, in order to remarry her former husband, has to observe the procedure of halala. Under the Muslim law, renunciation of Islam to conversion of husband to any other religious would have the effect of instantaneous dissolution of his marriage. Impotency is a ground for divorce under Dissolution of Muslim Marriage Act 1939. The most approved form of divorce under Muslim law is Talaq-e-Ahsan. The Constitutional Bench of Supreme Court decided the triple talaq case consistent how many women judge? 0. All are male judges, 5 judges. In which one of the following case the Supreme Court held that triple talaq would not be treated as a single talaq and not a valid talaq? Would be treated as a single talaq, not as a valid talaq. Sameem Aada case. Triple talaq's matter during vacation in Supreme Court was heard by bench of Justice J.S. Khair, Justice Karuna Joseph, Justice R.F. Nariman, Justice U.U. Lalit, Justice S. Abdul Nazir. S. Abdul Nazir and Karuna Joseph are dissenting judges. Muslim Women Protection Right on Divorce Act enable a Muslim woman to claim maintenance from her husband. A talaq can be effected either A or B, oral or spoken word or in writing. A Muslim husband email talaq letter writing, I divorce you, I divorce you, I divorce you, without the signature of witness. The talaq will be neither valid nor void. No talaq. A Muslim can divorce his wife whenever he so desired without assigning any cause, but only in presence of the wife. In which one of the following case the Delhi High Court held pronouncement of triple talaq at a time of Muslim husband resulting as single talaq only. Samim Ada versus State of UP. Which one of the following grounds is not available to Muslim wife? Seek the dissolution of marriage under Dissolution of Muslim Marriage Act 1939. Change of religion by husband. Khula under Muslim law refer to divorce initiated by wife and accepted by husband. Which one of the following enactment provide for dissolution of marriage at the instant of the wife only? Dissolution of Muslim Marriage Act 1939. Whether the consummation of marriage before the age of puberty deprives Muslim wife of her option of puberty under section 2 subsection 7 of Dissolution of Muslim Marriage Act 1939. Does not deprive.